if you're the anti-gun movement, New Jersey is on fire. Fire. And you don't like it because there have been no fewer than 3, I repeat, 3 separate judges, federal judges in New Jersey that have just spanked the anti-gun movement in that state. Stay tuned. We're going to talk all about that and the most recent victory for the Second Amendment that just occurred hours ago. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you haven't subscribed to the 4 Box of Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms and help us get to 100,000 subscribers. Help us with the social media algorithms. All right, folks, we have another major victory in the state of New Jersey today. A Joe Biden appointee to the federal bench, Judge Quraishi, who has, according to the Democrats, is the first Muslim appointee to the federal bench, an Article III judge in America, Judge Quraishi in the District Court of New Jersey. And today he just issued a major ruling in favor of the National Shooting Sports Foundation and the gun industry, claiming that the most recent law enacted by New Jersey to try to get around the federal preemption statute called the Protection of Lawful Commerce and Arms Act, or PLCAA, said that the attempt by New Jersey was illegal, not permitted, and preempted by federal law. So before we drill into that decision just a little bit, I want to just point something out about New Jersey. And I want to give everyone hope in places like California, Hawaii, Massachusetts, Illinois, and the like. I think New Jersey is a great teaching point of what is happening all across America when it comes to our Second Amendment rights. The anti-gunners threw a little non-strategic hissy fit after NSSF versus Bruin. And rather than being strategic, they went up there and got angry and passed all these silly laws that were clearly unconstitutional under the Second Amendment and NSSF versus Bruin and beyond. And that includes New Jersey. Thinking like, ha, 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 we got them, because the cover page and the editorial pages of places like the New York Times and the Washington Post say, hooray, 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 go get them. Well, that's all well and good, except we have something in this country called the rule of law and the United States Constitution and the Second Amendment, which is a fundamental right, not just any right, a fundamental right to keep and bear arms, according to the U.S. Supreme Court itself. Now, the reason why this is significant is that we now live in a world where you actually have judges who have been appointed to the federal bench by Democratic presidents who are following the law of NSSF versus Bruin and the Second Amendment. They've gotten the message that this is an equal fundamental right, and they're now ruling accordingly. This has got to make the anti-gun movement very upset because all their efforts in these legislators to violate Second Amendment rights are basically going up in flames. Let's just look at New Jersey over the last few weeks. I'm just talking the last few weeks to give us all hope across America. There's other states I can do this with, by the way. I just want to do it in New Jersey for the moment because it's occurred in the last couple of weeks. For example, we just talked about major decisions, including one yesterday by Judge Renee Marie Bumb, declaring that the vast majority of the so-called sensitive places as designated by New Jersey as government-mandated gun-free zones are not allowed under the Second Amendment. And there's some other things I think she would have ruled in our favor, but she ruled against the plaintiffs on the grounds of standing for the moment. But we'll get to those in future videos. For the moment, as Judge Bumb basically said that almost every place that New Jersey designated as a sensitive place, government-mandated gun-free zone, was unconstitutional under the standard NSSF versus Bruin, and I think that was the correct decision. And that was Judge Bumb. Multiple decisions in multiple cases involving the Second Amendment over the last month or so by Judge Bumb alone. Huge victory for the Second Amendment in New Jersey. But that's just the start, folks. Just the start. There's something that I don't think anybody else has picked up on. This is going to be news to you because I don't think anybody has figured this out. I noticed this a few weeks ago. I didn't say anything about it because I've been busy with other videos, but I want to flag it now. There was a decision by Judge Karen Williams in the District of New Jersey. Now, this is very interesting and very favorable. Judge Karen Williams is a federal judge appointed to the federal bench by Joe Biden. There was a dispute. It wasn't really much of a dispute, but there was somewhat of a debate and discussion as to which judge should take the Second Amendment cases, because there were two of them. There was a case called Siegel and a case called Coons. The Coons case was first decided by Judge Bumb in a major ruling in support of the Second Amendment. At the same time, Judge Williams had the Siegel case, also dealing with some of the same sensitive places issues in New Jersey. So with Judge Williams, seeing that Judge Bumb had already taken the lead in issuing her Second Amendment ruling, decided that she would transfer her case that she had in front of us, the Siegel case, and the Siegel case was the one involving the Association of New Jersey Rifle and Pistol Clubs, while the Coons case involved the Firearms Policy Coalition and the Second Amendment Foundation, by the way. So what Judge Williams said in the Siegel case is she was going to transfer it, and she did transfer that case over to Judge Bumb, thinking that they should all be, for judicial efficiency purposes, Judge Bumb should handle both of those cases because the issues are basically the same, a lot of the same considerations, the same law. So for judicial efficiency purposes, it made sense for one judge to handle both cases rather than have two different judges handle the two separate cases and have to do the same work twice. Not very efficient from the judicial system point of view, and that's why Judge Williams transferred the case of her Siegel case over to Judge Bumb, who was already handling the Coons case. Now, the reason why this is very important, and this is what has been missed, is footnote 1 of Judge Williams. I'll put a link to this down below. Judge Williams, a Biden judge, a Biden appointee to the federal bench, wrote footnote number 1 in her transfer order. Let me read you what Judge Williams, appointed to the federal bench by Joe Biden, wrote about the pro-Second Amendment decision by Judge Bumb, striking down virtually all of the sensitive places laws by the state of New Jersey, slapping the state of New Jersey around terribly as a matter of constitutional law. Here's what Judge Williams, the Biden nominee appointee to the federal bench, wrote. The court, meaning Judge Williams, having reviewed Judge Bumb's thorough, well-reasoned opinion and order on this matter, referring to the Coons case, including the supplemental submissions which address the impact of Judge Bumb's opinion and order on this matter and arguments and the relevant case law, I, the court, Judge Williams, key language here, finds no reason to reach a different result on the 5 provisions of Chapter 131 already enjoined by Judge Bumb. Close quote. You hear what I just said? Judge Williams, and appointed to the federal bench by Joe Biden, in transferring the Siegel case to the Judge Bumb's courtroom to be handled alongside of the Coons case, Judge Williams wrote that she read the opinion of Judge Bumb on the Second Amendment as applied to New Jersey's sensitive places and other laws, and she called Judge Bumb's decision to be thorough and well-reasoned. So here you have Judge Williams, a Biden appointee to the federal bench, literally saying that she supports and agrees with the opinion striking down the sensitive place laws of New Jersey, the same opinion order issued initially by Judge Bumb. So 2 judges in New Jersey, one a George W. Bush appointee, that's Judge Bumb, and also now you have Judge Williams in her footnote number 1 in the transfer order agreeing that she would agree, if she wrote the opinion, she would agree and issue the same decision against the state of New Jersey in favor of the Second Amendment. So here you have 2 decisions already in favor of the Second Amendment, one from Judge Bumb, one from Judge Williams. But that's not all, because today we have another major decision by another appointee to the federal bench by Joe Biden in the state of New Jersey. Specifically, Judge Quraishi, Judge Zahid Quraishi, issued an order today in favor of the gun industry and the National Shooting Sports Foundation over the arguments by the state of New Jersey and several sort of anti-gun groups that were trying to argue that the New Jersey law that sought to hold gun companies liable and get around the federal statute we're going to talk about in just 1 second was not appropriate. So specifically, what we have here is that back in 2005, Congress passed the Protection in Lawful Commerce and Arms Act. Okay? Now, the reason why they passed this is because for many years prior to that, many anti-gun organizations and anti-gun politicians were trying to sue the gun industry for crimes committed by third parties over whom the gun industry had no control. So if you make a gun today and 5 years from now some gangbanger uses that gun to commit a violent crime unrelated to anything you've ever done, well, I mean, they were getting sued, and this was costing them money with lawyers and time and effort, and it was an attempt to end run and harass the gun industry because, as you know, if you don't have a gun industry, not only do you have no ability to acquire guns if you support the Second Amendment, want to exercise your Second Amendment constitutional rights, but also if you're in the military or law enforcement, it hurts you there. So basically, Congress said that we need a robust American domestic gun industry, not just to provide Americans with firearms to exercise their Second Amendment rights, but also because we need a robust domestic gun industry to provide military weapons, arms, rifles and the like guns to the military and to law enforcement because we don't want to be dependent upon China, Russia, and other foreign countries for our firearms industry and for buying guns. That makes no sense. That would be terrible. So therefore, they didn't want to do that. And they passed this law in 2005. But there's some technical exceptions there, basically saying that even though gun companies can't be sued for liability of third-party criminal acts, there's some exceptions. Specifically, of course, if a gun company goes out there and lies about its product and says, hey, this gun shoots X number of bullets, when it doesn't shoot X number of bullets, you can still sue them over that. And there's things along those lines where you can still sue them, notwithstanding the fact that there is this federal law. But this 2005 law basically was trying to protect the gun industry from being sued by criminal acts of people who had no control, that the gun industry had no control over, which makes a lot of sense. That's basic black letter common law. Under tort law, it would never fly in any other context. But of course, you had anti-gun judges that were sympathetic and looking for ways to cooperate with plaintiffs' lawyers to get around this. And Congress basically enacted this law to try to nip that in the bud. But since then, there have been attempts by anti-gun states like New York and New Jersey to try to circumvent this law by trying to fall within one of the exceptions of the Protection of Commerce, Lawful Commerce and Arms Act. And the good news is that by and large this has failed. We can talk about the Sandy Hook case, which really had, which is a different animal there because that dealt with insurance money and bankruptcy and other technical legal things, which we don't need to get into this video. But bottom line, these states are trying to get around and take advantage of these exceptions of the 2005 immunity statute that protects the gun industry. And of course, with no guns, you have no ability to get guns because we have to be able to buy guns from somewhere and ammunition and the like. So again, to avoid these sort of harassment and efforts, they passed this federal statute. New Jersey tried to get around it, but Judge Quraishi today said that the attempt by New Jersey to get around it by creating this New Jersey-based nuisance statute was unconstitutional, illegal, specifically that it was preempted by the federal statute under the United States Constitution. If federal law conflicts with state law, federal law trumps. That's known as the doctrine of preemption. Sometimes you can see that in the context of what's called the Supremacy Clause, because the Constitution has something called the Supremacy Clause that says to the extent federal law is supreme, and to the extent state law and federal law conflict, federal law trumps state law, and that's what Judge Quraishi said. But there's something I want to read to you because this goes to another video we talked about. Remember, I taught you the doctrine of constitutional avoidance, and constitutional avoidance is the doctrine that says when a court has the ability to rule against a party but avoid a constitutional interpretation, then that is exactly what the court is supposed to do. And remember, I talked about this in the context of the pistol brace thing, where I think there are very strong Second Amendment arguments against the Biden pistol brace regulations. And as a consequence, I think that's going to enhance our chances of federal judge striking down the pistol brace regulation, not on Second Amendment grounds, interestingly enough, but on the grounds that it violates administrative law and the ATF exceeded its authority. But I do think the fact that you have a robust Second Amendment argument there actually strengthens other arguments other than constitutional arguments, because the judges often recognize there's a constitutional problem and they look extra hard to try to avoid the constitutional questions. And the best way of doing that is to rule against, for example, in this case, involving the National Shooting Sports Foundation against the state of New Jersey. So here is my point exactly. I want to read to you what Judge Quraishi said in support of the gun industry against the state of New Jersey. This is what he wrote in his opinion on page 14. I'll put a link to it down below. Quote, "The court," this is Judge Quraishi, "the court," Judge Quraishi, "additionally has concerns as to whether the statute, which is A1765, the New Jersey statute dealing with nuisance harassing gun industry, whether the statute can survive on constitutional grounds. However, because the court finds the National Shooting Sports Foundation is likely to succeed on the merits of its preemption argument, the court need not address the constitutional issues at this time." Period, close quote. Do you see what Judge Quraishi did? He did exactly what I would tell you that's going to happen in the pistol brace context. He said, look, I've got constitutional arguments here in favor of the National Shooting Sports Foundation against New Jersey. I've got non-constitutional arguments here involving preemption against the state of New Jersey. And he did, frankly, the right thing. He looked at this. He said there's no way that, in his view, that New Jersey can win on preemption grounds. So he ruled for the National Shooting Sports Foundation, the plaintiff against New Jersey, on federal preemption grounds. And he acknowledged that he awares there's really questions, major questions of constitutional considerations here, but he's able to avoid it using the doctrine of constitutional avoidance, not get to the constitutional issues, because he doesn't need to get to them in order to rule against New Jersey. This is just an example of what I'm talking about, the doctrine of constitutional avoidance, by having strong constitutional arguments on the one hand, you actually embolden and strengthen your non-constitutional arguments on the other hand. And remember, the goal ultimately is to win these cases. It doesn't matter about the grounds. It doesn't matter. The grounds sometimes do matter, but at the end of the day, if you prevent these laws that are anti-gun from going into effect, no matter how you do it, that is a good thing as far as I'm concerned. It vindicates our right to keep and bear arms and our other constitutional rights as well. Okay, so again, bottom line is Judge Bumb, Judge Williams, and Judge Quraishi in the last few weeks, 2 of the 3 were actually Joe Biden appointees in the state of New Jersey. And again, as far as I'm concerned, if you're an anti-gunner in the state of New Jersey, you are in big trouble. You got to be really worried about where the things are going, because the trend is the friend of the Second Amendment, as well it should be, because it's a textual-based constitutional right and a fundamental right, and attempts to try to circumvent it, to undercut it, to harass people that want to exercise it should not be permitted. And it looks like the courts in New Jersey are stepping up in a big way to vindicate the right to keep and bear arms, and it's about time, and I'm happy to see it. Okay, hope you learned a little bit something today here at the Four Boxes Diner. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.